Do you have contemporaneous examples, and by contemporaneous I mean shortly after the adoption of the 14th Amendment, where the states disqualified national candidates, not its own candidates, but national candidates?
The only example I can think of, Justice Thomas, is the example of Congressman Christie, who was elected in Georgia in, I believe, 1868, and the governor of Georgia refused or declined to certify the results of that election because Mr. Christie was disqualified. But I think it's not surprising that there are few examples because we didn't have ballots in the same way back then. Candidates were either write-in or they were party ballots, so the states didn't run the ballots in the same way, and there wouldn't have been a process for determining before an election whether a candidate was qualified, unlike the processes that we have now that states have created under their Article I and Article II powers to run elections. But
it would seem that particularly after Reconstruction and after the Compromise of 1877 and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it would seem that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. Did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising because there wouldn't have been, states certainly wouldn't have the authority to remove a sitting federal officer. So what's the purpose
of what was the purpose of Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples?
Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand the states controlling state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote, or McPherson, they all talk about, of course, the conflict after the Civil War, and there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making, and what I would like to know is do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article II and the 10th Amendment to run presidential elections. They didn't use that power to police ballot access until about the 1890s.
Counsel, it would seem that this case is a facial challenge. And to some extent, it relies on the overbreadth doctrine. But that seems to be an odd fit since respondent represents virtually all of the platforms, and that it would be easy enough for a platform who's affected to bring it as applied challenge. Would you comment on that? Or at least address the fact that this is a facial challenge?
Certainly, Your Honor. I do think that's a very significant aspect of this case. It comes to the court on a facial challenge, which means that the only question before the court is whether the statute has a plainly legitimate sweep. I actually don't understand them, Your Honor, to be making an overbreadth challenge, which, as I understand it, would rely on the effects on third parties. As I understand it, they're principally relying on the effects on their members. If they were bringing an overbreadth challenge, they would have to show various third-party statements.
Well, I think, how would they do that when they haven't shown that there's no way that this statute can be applied that's consistent with the Constitution? Have they met that?
They certainly have not, Your Honor. I mean, and we think the statute has indeed a plainly legitimate sweep. And certainly there are a number of the platforms that are open to all comers and content, much like a traditional common carrier. And just as a traditional common carrier, consistent with the First Amendment, would be subject to hosting requirements, non-discrimination requirements, so too we think that the platforms that satisfy that characterization, which are a number of them, absolutely would give this statute a plainly legitimate sweep.
Thank you, counsel. Mr. Clement.
Mr. Chief Justice, and may it please the Court, Florida's effort to level the playing field and to fight the perceived bias of big tech violates the First Amendment several times over. It interferes with editorial discretion, it compels speech, it discriminates on the basis of content, speaker, and viewpoint. And it does all this in the name of promoting free speech, but loses sight of the first principle of the First Amendment, which is it only applies to state action. Florida defends its law, as you've heard this morning, principally by insisting that there's no expressive activity being regulated. That blinks reality. This statute defines the targeted websites in part by how big their audience is. It regulates the content and display of particular websites, and it tries to prevent my clients from censoring speakers and content. If you are telling the websites that that they can't censor speakers, you can't turn around and say you're not regulating expressive activity. It's all over this law. And that brings it squarely within the teaching of Tornillo, PG&E, and Hurley. All three of those cases teach that you cannot have the forced dissemination of third-party speech, and they reject considerations of market power, misattribution, or space constraints. And Reno and 303 Creative make clear those principles are fully applicable on the Internet. Indeed, given the vast amount of material on the Internet in general and on these websites in particular, exercising editorial discretion is absolutely necessary to make the websites useful for users and advertisers. And the closer you look at Florida's law, the more problematic the First Amendment problems become. It singles out particular websites in plain violation of Minneapolis Star. Its provisions that give preferences to political candidates and to journalistic enterprises are content-based in the extreme. I welcome the Court's questions.
Mr. Clement, if the government did what your clients are doing, would that be government speech?
So it might be government speech, but I think it would be unconstitutional government speech, which is to say, when the government, obviously you have government speech cases, but when what the government's doing is exercising editorial discretion to censor some viewers or some speakers and not others, I think that plainly violates the First Amendment. And I think that's essentially the thrust of this Court's decision in the Manhattan Community cable case against Halleck, which is that in this area, looking for state action is absolutely critical. There are things that if the government does is a First Amendment problem, and if a private speaker does, we recognize that as protected activity.
Mr. Clement,
Can you give me one example of a case in which we have said the First Amendment protects the right to censor?
So I don't know that the Court used that particular locution, Justice Thomas, but I think that is the thrust of Hurley, that is the thrust of PG&E, that is the thrust of Tornillo. In all of those cases, a private party did not want to convey and disseminate the speech of a third party. And in every case, the government said, no, we have some really good reason here why this private party has to disseminate the message of a third party. And
I've been fortunate or unfortunate to have been here for most of the development of the Internet. And the argument under Section 230 has been that you're merely a conduit, which that was the case back in the 90s and perhaps the early 2000s. Now you're saying that you are engaged in editorial discretion and expressive conduct. Doesn't that seem to undermine your Section 230 arguments?
With respect, Justice Thomas, I mean, obviously you were here for all of it. I wasn't here for all of it. But my understanding is that my clients have consistently taken the position that they are not mere conduits. And Congress, in passing Section 230, looked at some common law cases that basically said, well, if you're just a pure conduit, that means that you're free from liability. But if you start becoming a publisher by keeping some bad content out, then you no longer have that common law liability protection. And as I understand 230, the whole point of it was to encourage websites and other regulated parties to essentially exercise editorial discretion, to keep some of that bad stuff out of there. And as a result, what Congress said is they didn't say, and you're still a conduit if you do that. No, it said you shouldn't be treated as a publisher, because Congress recognized that what my clients were doing would, in another context, look like publishing, which would come with the kind of traditional defamation liability, and they wanted to protect them against that precisely to encourage them to take down some of the bad material that, if these laws go into effect, we'd be forced to convey on our websites.
And it will empty a 100-round magazine like the ones used in the Las Vegas shooting in about 10 seconds. Those weapons do exactly what Congress meant to prohibit when it enacted the prohibition on machine guns, and those weapons are machine guns because they satisfy both disputed parts of the statutory definition. First, a rifle with a bump stock fires more than one shot by a single function of the trigger. In common usage today, as in 1934, a function of the trigger happens when some act by the shooter, usually a pull, starts a firing sequence. With a semi-automatic rifle, it fires one shot for each function of the trigger because the shooter has to manually pull and release the trigger for every shot. But a bump stock eliminates those manual movements and allows the shooter to fire many shots with one act, a forward push. Now, respondent says that a separate function of the trigger happens every time the trigger on a traditional rifle moves backwards and releases the hammer, even if it moves without any further manipulation by the shooter. But that is inconsistent with contemporaneous usage, does not account for guns with other kinds of triggers, and would make it trivially easy to evade the ban on machine guns just by automating the back and forth movement of the trigger after the shooter's initial pull. Second, a rifle with a bump stock fires more than one shot automatically, that is, through a self-regulating mechanism. Once the shooter presses forward to fire the first shot, the bump stock uses the gun's recoil energy to create a continuous back-and-forth cycle that fires hundreds of shots per minute. A respondent says that that cycle is not automatic because the shooter has to keep up the forward pressure to keep the cycle going. But many traditional machine guns likewise require the shooter to maintain backward pressure on the trigger to maintain continuous fire. Either way, a single motion both initiates and maintains a multi-shot sequence, and either way, the weapon is a machine gun. I welcome the Court's questions.
Mr. Fletcher, how does a machine gun, what would I have to do to fire a machine gun?
It depends on the machine gun. Some it's a push of a button. Some it's a pull of a trigger. The statutory definition is, does it shoot more than one shot automatically by a single function of the trigger?
But I don't have to do anything else. I don't have to put pressure on it or anything else.
It depends on the gun, again. So if you imagine, I think what your question is getting at is if you take a traditional M16 rifle, that we often think of when we think of a machine gun, you're right. To fire more than one shot, you pull the trigger and you have to hold it back, and as long as you maintain that backward pressure on the trigger, it keeps shooting.
With a bump stock, what would I do different?
You would do different, both the initial motion and the motion that continues. It's the same thing in the sense that one motion automates back and forth movement and results in multiple shots.
So what is happening with a trigger initiated firing of a machine gun? What do I have to do other than to press the trigger?
With a traditional machine gun, again, take an M16, and again, we think they're all machine guns, but I understand the question to be, take an M16, you pull the trigger back and you hold it and it keeps shooting. Okay. With a bump stock, you push forward and that both initiates and continues the firing.
And what is happening with the trigger when you have the recoil?
That's exactly right. So I think this gets to respondents' primary argument on function of a trigger, which is that the difference with a bump stock is that it fires multiple shots automatically by automating the movement of the trigger. So my friend says the trigger moves back and forth every time a shot is fired. Our view is that those subsequent movements of the trigger aren't functions of the trigger because they're not responding to separate acts, separate pulls, or anything else by the shooter. They're just the result of the
So what is
automated
happening with the trigger when someone doesn't need a bump stock to bump fire a weapon?
So this is the unassisted manual bump firing that's described, where an expert can take a regular semi-automatic rifle and hold it loosely enough that they can do something like bump firing. And I think in our view there too, there's just one function of the trigger because the first push starts the sequence and then the sequence continues. The ATF explained, and we agree, that that's not automatic because there's no self-regulating mechanism. The user has to
So
control
what's the
recoil.
difference? The same thing is happening with the trigger.
The same thing is happening with the trigger, and I think that's why we would say with manual bump firing, there is just a single function of the trigger. There's one action that initiates the firing sequence. We think it's not automatic because there's no self-regulating mechanism. The user is having to do all of the work that the bump stock automates for you on a rifle fitted with a bump stock.
Thank you, Mr. Fletcher. How are we supposed to evaluate that question and what the level at which coercion kicks in? I mean, if you're trying to coerce or get a particular result out of a media outlet, is it enough to say, if you don't do this, we're going to move your reporter's cubicle down the hall? Or how do you evaluate when it constitutes coercion in this context?
So let me start with, I think Bantam Books has been the lodestar for the lower courts that have mostly coalesced with some errors in application like this case around the idea of the question is it a threat or a statement that a reasonable person would understand, viewed objectively and in context, as an implicit or explicit threat of some adverse government action? Now, as to the cubicles question, I sort of don't know if there are some adverse government actions that are so trivial that they don't count. I guess I think something like that seems less likely to be a coercive threat. But in general, I think our position is if there's something that the government is saying that we're going to exercise government power in some way unless you change your speech in some way or stop distributing the speech of others, if it's reasonably understood as that sort of a threat, that's a First Amendment problem.
Well, but under Bantam Books, it presumably is in context what you're talking about, a reasonable person. I mean, if there is, as a regular basis, the kind of back and forth between a spokesman and a member of the media, what a reasonable person might view as coercive might not in that context. Maybe the press secretary yells on a regular basis, and if their volume increases enough, that might be viewed as coercion.
So I think that points up the context sensitivity, and I think, as is usually the case when the court says it's a reasonable person test, it's a reasonable person with knowledge of all the facts, and I think that would include the prior course of dealing between the relevant government official and the relevant recipient. I think here that really strongly reinforces the idea that there wasn't coercion. These were sophisticated parties. They routinely said no to the government. They were open about it. They didn't hesitate to do it. And when they said no to the government never engaged in any sort of retaliation. Instead, it engaged in more speech. Ultimately, the president and the press secretary and the surgeon general took to the bully pulpit. We just don't think that's coercive.
Thank you. Justice Thomas?
Mr. Fletcher, back to my point about coercion. Couldn't you simply do the censor someone or prevent other speech by others by agreeing with the platforms as opposed to coercing the platforms?
I guess I'm not sure what you mean by agreeing with the platforms.
Well, you just work together, said, look, we're right, they're wrong. Let's work together. We're on the same team. Let's work together to make sure that this misinformation doesn't gain sort of any following.
So I think as long as the platforms are exercising their own independent judgment, that's what the First Amendment protects. It says we don't want the government messing
So
with.
you're saying that the government can't censor by coordinating with private parties to exclude other speech?
I'm saying that when the government persuades a private party not to distribute or promote someone else's speech, that's not censorship. That's persuading a private party to do something that they're lawfully entitled to do. And there are lots of contexts where government officials can persuade private parties to do things that the officials couldn't do directly. So, for example, in recently after the October 7th attacks in Israel, a number of public officials called on colleges and universities to do more about anti-Semitic hate speech on campus. I'm not sure, and I doubt that the government could mandate those sorts of changes in enforcement or policy, but public officials can call for those changes. The government can encourage parents to monitor their children's cell phone usage, or internet companies to watch out for child pornography on their platforms, even if the Fourth Amendment would prevent the government from doing that directly. All of those are contexts where the government can persuade a private party to do something that the private party is lawfully entitled to do, and we think that's what the government is doing when it's saying to these platforms, your platforms and your algorithms and the way that you're presenting information is causing harm, and we think you should stop, and the platforms are.
So you really don't see any difference between the government coordinating with the platforms to exclude other speech and persuading the platforms to do this, to not engage or permit other speech?
I guess I'm not seeing it, and I think that what happened here was definitely on the, if you do think there's a difference between those two things, I guess my argument here would be that what happened is on the persuasion side of the line, because you do see that back and forth of the platforms throughout the process saying no repeatedly when they disagree with what the government is asking them to do, and I think that that tells you that what was happening here is what the First Amendment protects, which is private speakers making independent judgment, informed by, maybe even influenced by the government.
So there's no difference between the platforms meeting and working out an arrangement not to permit certain speech and the platforms working with the government to do the exact same thing. There's no difference.
Well, I think if the platforms entered into some agreement amongst themselves, that might raise issues under different provisions of the law. The modest point I'm making is just that the government doesn't violate the First Amendment when it persuades a speaker to not distribute speech by someone else. That's Penthouse versus Meese, Judge Silberman's opinion there. That's what happens when the White House press secretary calls up the New York Times and says that was a bad op-ed, you shouldn't run op-eds like that anymore. I think that's commonplace.
Thank you. General Prelogar.
Mr. Chief Justice, and may it please the Court. On January 6, 2021, a violent mob stormed the United States Capitol and disrupted the peaceful transition of power. Many crimes occurred that day, but in plain English, the fundamental wrong committed by many of the rioters, including petitioner, was a deliberate attempt to stop the joint session of Congress from certifying the results of the election. That is, they obstructed Congress's work in that official proceeding. The government accordingly charged petitioner with violating Section 1512C2, an obstruction offense that directly reads onto his conduct. The case as it comes to this court presents a straightforward question of statutory interpretation. Did petitioner obstruct, influence, or impede the joint session of Congress? The answer is equally straightforward. Yes, he obstructed that official proceeding. The terms of the statute unambiguously encompass his conduct. Petitioner doesn't really argue that his actions fall outside the plain meaning of what it is to obstruct. Instead, he asks this court to impose an atextual limit on the actus reus. In his view, because Section 1512C1 covers tampering with documents and other physical evidence, the separate prohibition in Section 1512C2 should be limited to acts of evidence impairment. But that limit has no basis in the text or tools of construction. His reading hinges on the word otherwise, but that word means in a different manner, not in the same manner. And the true prohibitions in Section 1512C2 aren't unified items on a list where you could apply associated words canons. They're separate provisions. They have their own sets of verbs and their own nouns. They each independently prohibit attempts, which would be duplication that makes no sense on petitioner's reading. And Congress included a distinct mental state requirement in C1 that it chose not to repeat in C2. Section 1512C2, by its terms, is not limited to evidence impairment. Instead, it's a classic catch-all. C1 covers specified acts that obstruct an official proceeding, and C2 covers all other acts that obstruct an official proceeding in a different manner. The court should say so and allow this case to proceed to trial. I welcome the court's questions.
General, there have been many violent protests that have interfered with proceedings. Has the government applied this provision to other protests in the past, and has this been the government's position throughout the lifespan of the statute?
It has certainly been the government's position since the enactment of 1512c2 that it covers the myriad forms of obstructing an official proceeding and that it's not limited to some kind of evidence impairment gloss.
Have you enforced it in that manner?
We have enforced it in a variety of prosecutions that don't focus on evidence tampering. Now, I can't give you an example of enforcing it in a situation where people have violently stormed a building in order to prevent an official proceeding, a specified one, from occurring with all of the elements like intent to obstruct, knowledge of the proceeding, having the corruptly mens rea, but that's just because I'm not aware of that circumstance ever happening prior to January 6th. But just to give you a flavor of some of the other circumstances where we have prosecuted under this provision, for example, there are situations where we've brought C2 charges because someone tipped off the subject of an investigation to the grand jury's hearings. There was another case where someone tipped off about the identity of an undercover law enforcement officer, and in those situations, there's no specific evidence, no concrete testimony or physical evidence that the conduct is interfering with. Instead, it's more general obstruction of the proceeding. Justice Alito mentioned the Wright case as well, and that's another one where it was a forged court order that prompted the litigant to dismiss a mandamus petition, but that didn't have anything to do with the evidence that was going to be considered in that proceeding.
So what role does C1 play in your analysis?
So we understand 1512c to split up the world of obstructive conduct of an official proceeding into the C1 offense and into C2. C1 covers everything it enumerates. It's the acts of altering, concealing, destroying records, documents, or other objects. And then C2 would only pick up conduct that obstructs an official proceeding in a different way. So there's no duplication or superfluity on our reading. Instead, Congress was taking this universe and dividing it up into the two separate offenses. And I think that's actually a virtue of our reading as compared to petitioners, because I have not heard him articulate anything that would fall within C1 that wouldn't also come within C2. So on his reading, C2 really does just swallow C1 whole.
Well, I mean, in the way you're reading it, C2 almost exists in isolation, certainly not affected by C1.
We don't deny at all that there is a relationship between the two provisions, Justice Thomas.
What is that relationship?
And the relationship is the one Congress specified in the text. It's what follows the word otherwise. That is the relevant degree of similarity. What both C1 and C2 have in common is that they or aim at conduct that obstructs an official proceeding. C1 does so in one way, tampering with records and documents. C2 does so with respect to all other conduct that in a different manner does that. And I think that this has to be the road the court goes down, to look at what Congress actually prescribed with respect to similarity. Because in contrast, if you take up petitioner's invitation to come up with some atextual gloss from C1 to port over into C2, I don't understand what the court could look at to guide its determination of exactly what the relevant similarity would be.
Mr. Kneedler?
Mr. Chief Justice, and may it please the court. In Robinson, this court held that the government cannot criminalize status, and respondent has conceded here today that the city cannot criminalize the status of being homeless. Our narrow submission in this case is that government cannot circumvent the principle of Robinson by making it unlawful for a person to reside in the jurisdiction if he has that status. That is what the ordinances here do. As applied to someone who has nowhere else to sleep, which is an essential human function, the ordinances are the equivalent of making it a crime to be homeless while living in Grants Pass. Although we think the Ninth Circuit was right to recognize that the core principle of Robinson is implicated in this case, the court was wrong to award broad injunctive relief in the circumstances and manner in which it did. The Robinson principle requires an individualized determination, and the Ninth Circuit's failure to require such a determination and its issuance of much broader injunctive relief has led to the problems at issue that the petitioner and its amici have raised, not the core principle of Robinson. And therefore, we urge the court to adhere to the core principle of Robinson, but to emphasize that cities have flexibility to implement these, and in particular, time, place, and manner restrictions on where someone can sleep are entirely valid if they are reasonable. And indeed, the state law that Justice Jackson referred to establishes a state policy that time, manner, and place restrictions are the way to go if they are reasonable. I welcome the Court's questions.
Mr. Needler, wouldn't you have a better argument if Robinson involved someone being arrested for using drugs, but then the court said that you were in effect arresting him for the status of a drug user because he had no choice but to use drugs because he's an addict?
No, our position is not that the conduct, as in Robinson, the drug addict can't stop from using drugs. That is not our position. That's a question of personal culpability on the basis of what.
So what's the difference between that and camping out? What you're saying here, it seems as though you're saying, well, there's no other choice, so you have to camp out. Therefore, you're really arresting this person for the status of homelessness.
Yes, but not because of an involuntary compulsion sense. I think, as Justice Alito pointed out, the nexus here is actually closer than in the addiction situation, because sleeping outside is essentially the mirror image of the other side of the coin, or the definition of the status of homelessness.
Ms. Corcoran?
Mr. Chief Justice, and may it please the Court, Robinson v. California holds that status-based punishment schemes are categorically cruel and unusual under the Eighth Amendment. The challenged ordinances inflict status-based punishment in both effect and purpose. Although the city describes its ordinances as punishing camping on public property, it defines campsite as any place a homeless person is while covered with a blanket. The city interprets and applies the ordinances to permit non-homeless people to rest on blankets in public parks, while a homeless person who does the same thing breaks the law. The ordinances, by design, make it physically impossible for homeless people to live in Grants Pass without facing endless fines and jail time. The only question under Robinson is whether there's any meaningful difference between a law that says being homeless is punishable and a law that says being homeless while breathing or sleeping or blinking is punishable. In other words, does adding a universal human attribute to the definition of the offense make the punishment conduct-based instead of status-based? The answer is no. The purpose and effect of the second statute is exactly the same as the first, to make people with the status endlessly and unavoidably punishable if they don't leave Grants Pass. Indeed, all the ordinances do is turn the city's homelessness problem into someone else's problem by forcing its homeless residents into other jurisdictions. The injunction below leaves the city with an abundance of tools to address homelessness. It can impose time, place, manner restrictions on when and where homeless people sleep. It can ban tents and clear encampments. It can enforce the sleeping ban against homeless people who decline shelter. And it can fully enforce its laws prohibiting littering, public urination and defecation, drug use, and violent or harassing behavior. The only tool the city wants that it doesn't have is authority to impose a 24/7 citywide sleeping ban that forces its homeless residents to either move to another jurisdiction or face endless punishment. The state police power is broad, but it does not include the power to push the burdens of social problems like poverty onto other communities, or the power to satisfy public demand by compromising individual constitutional rights. I welcome the Court's questions.
In Robinson, there was a statute that said that to be addicted is a crime. Is there an ordinance here that says to be homeless is a crime?
So the language for the purposes of a temporary place to live bakes homelessness into the definition of the offense. Justice Sotomayor was talking about that earlier. So when you combine that language with the rest of the camping definition, what you have is an ordinance that says being homeless while sleeping with a blanket is punishable. And as I just said earlier, the question becomes when you attach the status to the universal attribute of sleeping, does it then transform the offense into a conduct-based punishment instead of status-based punishment? I think the answer is no.
Mr. Chief Justice, and may it please the Court. Section 10J authorizes district courts to grant preliminary injunctions that they deem just and proper. 10J thus requires district courts to apply the traditional 4 factors as set out in Winter versus NRDC. This court should reverse. The Court of Appeals held that Winter's 4 factors do not apply under Section 10J. All that mattered below was whether any facts supported a non-frivolous legal theory and whether there was harm, not whether that harm was irreparable. The government argues that whether a 2- or 4-part test governs, statutory context compels district courts to conduct, quote, a less exacting and more deferential inquiry into the merits without undertaking an intensive effort to resolve factual issues. But 10J contains no language, much less clear language, diluting the traditional standard. Preliminary injunctions are extraordinary and drastic remedies. Here the board seeks a coercive injunction backed by contempt sanctions, and the board seeks the very same injunctive relief that it would get if it won the case. Such relief is highly inappropriate absent a clear showing under all 4 factors. The government justifies deference because the board, not trial courts, ultimately decide the merits at the back end. But Congress directed trial courts, not the board, to apply the Winter factors at the front end. The board hasn't even made any factual findings to defer to. Agencies have no expertise whatsoever in how courts should exercise their equitable discretion. Indeed, the board, in its adjudication, will not even consider the 4 Winter factors. This court has never deferred to an agency's litigation position, and it should not start here. I welcome your questions.
Ms. Blatt, the government says that petitioner's ahistorical, decontextualized approach is inconsistent with the statutory text, the basic premises of equity, and over a century of case law. What's your reaction to that?
No. I don't even know where they're getting that. I mean, this court in Winter and a million other cases have said that these 4 factors are longstanding, and the clear statement rule goes back to Justice Story. But I just think the text on its face, you don't have to get too far, says just and proper. That's obviously harks to traditional equity, and here we have the 4 factors.
Do you think the government argues that because they are protecting the board's jurisdiction as opposed to the court's jurisdiction, that that's a difference?
Not at all. Not at all. I mean, a preliminary injunction, I mean, it's assigned to the district court. It has the same reasons. You have to show that there's a likelihood of success on the merits. And obviously, if the harm is recoverable, you're not entitled to the injunction at all in balance of the equities. There's no, I don't even understand the board's jurisdiction. There are a multitude of contexts where an agency has an adjudication, and if it wants a preliminary injunction, it's got to make the showing that every other party would have to make.
Mr. Dreeben, does the president have immunity, or are you saying that there's no immunity, presidential immunity, even for official acts?
Yes, Justice Thomas, but I think that it's important to put in perspective the position that we are offering the court today. The president, as the head of the Article 2 branch, can assert as applied Article 2 objections to criminal laws that interfere with an exclusive power possessed by the president or that prevent the president from accomplishing his constitutionally assigned functions. That is the constitutional doctrine that currently governs the separation of powers. What petitioner is asking for is a broad blanket immunity that would protect the president, a former president, from any criminal exposure absent impeachment and conviction, which has never happened in our history. And we submit that is not necessary in order to assure that the president can perform all of the important tasks that the Constitution reposes in him.
Over in not so distant past, the presidents or certain presidents have engaged in various activity, coups or operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions. Why? If what you're saying is right, it would seem that that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes. And I want to explain why there are layers of safeguards that assure that former presidents do not have to lightly assume criminal liability for any of their official acts. At the outset, there is a statutory construction principle that is applicable here. It arises when there is a serious constitutional question about applying a criminal statute to the president's acts. It is not, and I'm sure that we will discuss this, that no statute can apply to the president in his official capacity absent a designation of the president in it. But there is a principle that if there is a serious constitutional question, courts will strive to construe the statute so that it does not apply to the president. In addition to that, the president, I think has been mentioned earlier, has access to advice from the Attorney General, and it would be a due process problem to prosecute a president who received advice from the Attorney General that his actions were lawful, absent the kind of collusion or conspiracy that itself represented a criminal violation, which I don't really see as being a realistic option. And then if I could say one more thing, because you raised the question about potential overseas taking of life. And the Office of Legal Counsel has addressed this quite specifically. There is a background principle of criminal law called the public authority exception to liability, and it is read into federal law unless Congress takes specific action to oust it, which it never has done as far as I am aware. And in a case in which the president sought to engage in overseas activity that would result in the taking of life, OLC did not say the federal murder statute doesn't apply. That would be the thrust of my friend's argument on clear statement. Instead, OLC went through an extensive analysis on why the public authority defense would prevent it from being considered a violation of law to go after a terrorist, for example.
Well,